Get ready for the dictation. Start. A petition came to be filed in this court by one Mehak Maheshwari, bringing to the notice of this court a tweet made by Mr. Prashant Bhushan, advocate, alleged contemner number 1, praying therein to initiate contempt proceedings against the alleged contemners for willfully and deliberately using hate/scandalous speech against this court and entire judicial system. The registry placed the said petition on the administrative side of this court, seeking direction as to whether it should be listed for hearing or not, as consent of the signature not verified learned Attorney General for India had not been obtained by digitally signed by Gulshan Kumar, the said Sri Maheshwari, to file the said petition. Examining the matter on the administrative side, this court on the administrative side directed the matter to be listed on the judicial side to pass appropriate orders. Accordingly, the petition was placed before us on 22/7/2020. On the said date, we passed the following order. This petition was placed before us on the administrative side whether it should be listed for hearing or not, as permission of the Attorney General for India has not been obtained by the petitioner to file this petition. After examining the matter on administrative side, we have directed the matter to be listed before the court to pass appropriate orders. We have gone through the petition. We find that the tweet in question made against the CJI is to be following effect. CJI rides a 50 lakh motorcycle belonging to a BJP leader at Raj Bhavan, Nagpur, without a mask or helmet at a time when he keeps the SC in lockdown mode, denying citizens their fundamental right to access justice. Apart from that, another tweet has been published today in the Times of India, which was made by Sri Prashant Bhushan on June 27, 2020, when he tweeted, "When historians in future look back at the last 6 years to see how democracy has been destroyed in India even without a formal emergency, they will particularly mark the role of the Supreme Court in this destruction, and more particularly the role of the last 4 CJIs. We are prima facie of the view that the aforesaid statements on Twitter have brought the administration of justice in disrepute and are capable of undermining the dignity and authority of the institution of Supreme Court in general and the office of the Chief Justice of India, particularly in the eyes of public at large. We take suo motu cognizance of the aforesaid tweet also, apart from the tweet quoted above, and suo motu register the proceedings. We issue notice to the Attorney General for India and to Mr. Prashant Dhawan, advocate also. Shri Sajan Puvaiya, learned senior counsel, has appeared along with Mr. Priyadarshi Banerjee and Mr. Manu Kulkarni, learned counsel, appearing on behalf of the Twitter, and submitted that the Twitter Inc. California USA is the correct description on which the tweets were made by Mr. Prashant Bhushan. Let the reply be also filed by them. In response to the notice issued by this court, both the alleged contemners have filed their respective affidavit. In reply, Mr. Prashant Bhushan, the alleged contemner number 1, has filed a detailed affidavit running into 134 pages, which along with the annexures runs into 463 pages. The main contention of the alleged contemner number 1 in that insofar as the first tweet is concerned, it was made primarily to underline his anguish at the non-physical functioning of the Supreme Court for the last more than 3 months, as a result of which fundamental rights of citizens such as those in detention, those destitute and poor, and others facing serious and urgent grievances were not being addressed or taken up for redressal. It is contended that it was made to highlight the incongruity of the situation where the CJI on one hand keeps the court virtually in lockdown due to COVID fears, with hardly any cases being heard, and those heard also by a unsatisfactory process through video conferencing, and on the other hand is seen in a public place with several people around him without a mask. It is his submission that expressing his anguish by highlighting the said incongruity and the attendant facts, the first tweet cannot be said to constitute contempt of court. It is submitted that if it is regarded as a contempt, it would stifle free speech and would constitute an unreasonable restriction on the right of a citizen under Article 19(1)(a) of the Constitution. Stop.